Good day, and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in today's episode, we're tying the knot, clinking our glasses, and taking a deep dive into patent nuptials. You have your big idea, and now it's time to breathe it into existence, but you need some help with the development. Like many others, you turn to the aid of an engineering firm or dev shop. This relationship is a marriage of sorts, but it's a marriage that's designed to inevitably end in divorce. How cleanly, smoothly, and successfully this separation goes depends on the steps you take before it officially begins. In this month's episode, Dr. Ashley Sloat, President and Director of Patent Strategy here at Aurora, leads a discussion into responsible engagement with engineering firms, or what we affectionately refer to here as prenuptial patenting. Ashley and our all-star patent panel walk you down the aisle and explore everything you need to know to experience marital bliss and an amicable divorce with your engineering partners. This talk covers the full life cycle from vetting partners to post-development concerns and everything in between, with particular focus on relationship complexities like IP ownership, assignment from engineering firm inventors back to you, and how to avoid the traps of viral IP. Ashley is joined today by our always exceptional group of IP experts, including Kristen Hansen, patent strategist here at Aurora, and David Jackrell, president of Jackrell Consulting. And now just one quick announcement before joining the panel. We're very excited to share that we've been invited to speak at this year's Innovator MD World Congress. This is the world's largest physician innovation event. It'll be happening both virtually on Zoom and in person in San Francisco, August 17th through the 20th. Ashley will be on-site and conducting a workshop covering the most common patenting mistakes made by inventors and startups. She'll highlight best practices for not making the mistakes in the first place, and we'll explore available remedial options in cases where it's too late for avoidance. We're really looking forward to the conference and this talk. If there was a guidebook we could hand to inventors on the first day following conception of their idea, this would be it. We've included a link in the show notes that you can use for more details on tickets and how to attend. Now, without further ado, I'll hand it over to your host and part-time marriage counselor. Take it away, Ashley.
This whole conversation today is around engagement with engineering firms and around how to effectively secure IP while engaging with engineering firms. And so kind of thinking through this, not only as a patent practitioner, but almost as like a divorce attorney or something like that, because it's all about, kind of the preparation and thinking through how things could go wrong, how they might go wrong, and hoping that you never have to enact some of these documents that you ultimately create. And so kind of just, again, kind of walking through all stages of that relationship with an engineering firm. And so hopefully talking about today, again, key considerations for working with firms, who owns the IP resulting from the relationship. And obviously this can be drafted to be really any party, but just how do you make sure that you own what you want to own? And then ownership of IP versus inventorship of IP. And then whose responsibility is novelty and inventiveness of the new product? Because I think sometimes there's some ambiguity, at least for the client, around whose responsibility that is. So obviously there's huge value in a patent, and there's some of the strongest forms of protection, but there's also lots of other forms of IP, trademarks, copyright, trade secret, design patents. And so there's also immense value to outsourcing your product development. It's obviously time tested. There was a recent study that found that over 90% of respondents worked with a partner to develop and manufacture their IoT solution. Some 43% of software companies outsource their software development. Obviously, these companies that have this capability to develop products for other companies, they have huge infrastructure. So the client doesn't have to develop that infrastructure. They have relationships with existing partners. It reduces a client's upfront commitment. You can also leverage their expertise that they have in-house, and it allows you just to move a lot quicker, right? Because hiring is expensive, hiring takes a long time. And then how do you hire for somebody with expertise that you personally don't have? It can be hard. So just partnering with a dev shop can be a lot easier. We're not saying that you have to, but just I know a lot of companies do it, and there's a lot of value there. And it's obviously also highly flexible, right? You can do an MVP, you can do different features with them, you can scale it up and tailor it back as needed. But I think the biggest problem that we've seen is navigating what you're going to own at the end of it versus what the firm is going to own at the end of it, right? Because everybody brings different things to the partnership. and you have to figure out a way to take those puzzle pieces back apart at the end and everybody get what they thought they should get out of that relationship. And so kind of walking through, we kind of correlated this obviously kind of with dating, because it is very much like dating. You have a single life, right, where you're trying to get all your house in order, right? Get your IEP in order, get your documents in order, get your contracts in order. Then you're going to go through dating and vetting different partners, maybe getting recommendations from other partners that you work with, having meetings. There's going to be an engagement or prenuptial period where you're going to work through the contract with that potential engineering firm. And then there's the marriage, which is the actual product development, where you're kind of working together in harmony to develop this product. And then ultimately, most likely you're going to have some kind of divorce at the end of it to basically divvy back up that IP. And then you walk away with your developed product and they go back and serve other clients. And so, this is obviously different than typical marriage, or in theory it is, right? Because it almost always ends in divorce, right? That's the whole goal, is that you come together to develop this beautiful product and then you kind of split up at the end. But I also have a few anecdotal experiences that, of course, Kristen and Dave, feel free to jump into if you think of anything. So in the single life for companies, I think the biggest thing is that you want to reduce your disclosure risk. So that, of course, includes getting non-disclosure agreements before you talk with anyone. Of course, this is going to ebb and flow a little bit with who you're talking with. Investors and whatnot won't necessarily sign NDAs, but engineering firms should be willing to sign the NDA. Just make sure that that NDA, and I think I touch on this later, but make sure that NDA does not have contract language in it. Some companies like to spill other contract language into an NDA. Just make sure your NDA is a pure NDA. That's all it needs to be at this point. It doesn't need to be anything more. Inventorship and ownership, making sure you get as much IP on file as soon as possible before you start talking with different firms or establishing relationships with them. This is where the value of a provisional comes in. It comes into play and has high value. It'll establish obviously your client's IP and your ownership of that idea versus whatever the engineering firm is bringing to the table. And so I think that's probably what the biggest important piece of this is. Just, you want that clear line before you start any partnership, and a provisional is a good way to do that.
Yeah, I agree. I think part of the technique there is to get your ideas on file in some sort of provisional, even if it's cover sheet, right? Mm-hmm. And then as you work with that engineering firm, if they come to some novel ways of solving some of the problems that you have either created by creating the product or just ran into and needed fixing, it serves a really good way of filing two applications, one on your original idea with many bells and whistles that aren't related to whatever problem this engineering firm solved, and they can file something with you on a second application. And dividing those, usually isn't a problem, because usually even if you tie it back to the date, as long as you're not getting restriction requirements and things that are going to be a problem in the divorce, it's usually okay to tie it back to the date of the parent provisional, but you may not actually follow through with that tie back in the end, because those claims may have actually been created later. It's something where by procedure we usually tie it back and we pull them off the original provisional, but in practice, if you ever had to uphold those claims, it's unlikely that that date would hold up for the new claims of the engineering firm because of when they came into the process, time-wise, right? Mm-hmm. So even if you strategically tie it just because it happens to be related and it happens to share some inventorship, it's possible that that wouldn't hold up anyway.
Yeah, I think the other interesting part too that I've seen, not necessarily from an engagement with an engineering firm, but even when you working with universities, if you're using expertise from a university, we've seen it where we do a provisional with the stuff that was fully conceived of with just the client, and then a separate provisional of the material that was conceived of in partnership with the university people. So then there's also clear ownership lines there of, as we know, universities tend to take everything that they've that's been developed kind of under their umbrella. outside of, there's some exceptions like undergrads and things like that, those that are paying for their education. But and I think the same way here, kind of like what you were saying, Kristen, is if that one, you have very clear delineation between what the company did versus what the third party did in collaboration with the company. But then you also, if for some reason something happens with that engineering firm, that IP that's related to that engineering firm is completely separate as well, right? If they become difficult to work with or something like that, that IP hasn't like infiltrated other aspects of the portfolio. You've kind of segmented it off.
Yeah. And and that's a really good example, because universities are always trying to license what they've got. Okay. So rather than, Joe Blow engineer one and engineering firm two, who, may license something, but they're really probably trying to block others from doing what they're doing and selling what they're doing. They're not likely going to license it unless they're, up for selling it at some point. Or it's, brilliant, right? So many patents don't get licensed, but it's more likely that they would when you have somebody actively searching for a licensee, which is most universities. So that's a really good situation to divide that up as soon as you can.
Yeah, I was gonna echo the exact same thing, and especially in these situations where you have a primary company who's trying to outsource something. So it's like different than a joint development agreement between two sort of equal partners. This is one where it's like one company is trying to outsource something, but the company is the driver. We would always tell people to file all your ideas in a provisional, and even maybe think ahead. So if you're going to engage with this other firm and they're going to be developing products, put all of your ideas for that product down before you engage with them, have a record of that. So then, like you are both saying, it's so much cleaner, clearer. There's documentation about what exactly you did have possession of before you engage. And then I think you're going to get to it. But then, of course, the next step is the agreement of, okay, if something is jointly developed, then who owns that? Right?
Yep. Yeah, exactly. No, 100%. And yeah, we'll talk about that in more detail for sure, because it can be crafted any way you want it to be. But there are probably some ways where you more likely than not want it to be. So just for obviously anybody who doesn't know non-disclosure, I know you both do, but obviously non-disclosure ensures full confidentiality of all IP assets, limits third-party disclosure without permission, ideally signed by, the giver of the information and the receiver of the information. But again, like I said, shouldn't include statement of work or IP agreement language. Now, a statement of work or IP agreement might have non-disclosure language in it, but it's not typical for an NDA to have statement of work or IP language in there, because you're kind of jumping the gun a little bit then by putting that in there.
There's a quick comment on NDAs, because it's very related to what we were just talking about. But I feel like a mistake that some people I've seen make is they try to rely too much on an NDA. And thinking about like what we were just talking about, the NDA is great. Of course, we always recommend that. Some people take them more seriously than others, so there is risk there. But in the NDA, it's not going to say specifically the technology that you were in possession of earlier, or the other company was in. And that's where all these filing, the provisionals before you engage, comes in together with the NDA, right?
Mm-hmm. Yeah, that's a good point, because it's in a vacuum, an NDA doesn't say a whole lot, right? It just says, as of this date, anything that we've discussed, but who knows outside the people in that room or any documentation that was created, who knows what was discussed, right? Whereas having a patent application on file really clearly spells it out, what was clearly known before that meeting happened, right? And really clearly says, this is what we had. And that maybe just goes towards documentation as well, just in general from a NDA meeting perspective, just really having good documentation too. So if you are relying on an NDA, you have good documentation to prove what was in that meeting then at minimum, right?
Yep.
All right. So then you're going to start vetting partners, the dating aspect, and kind of a Tinder, although I don't think I've ever used that app. I couldn't even tell you. All I know is you got to swipe left. So we're going to talk about swiping left a few times. So you want to consider several things when you're dating different engineering firms or vetting them. Obviously, geography and jurisdiction. this is the biggest pie aspect comes in terms of time zone differences, and if you can work well with different time zones, right? If that's going to work okay within the workflow that you have established. But also legal jurisdiction. Is that going to, if something goes awry, having part of the different teams in different legal jurisdiction, is that going to cause a problem for enforcing anything that you've set out, whether it be an NDA or some kind of agreement that you set out? And remember that IP law is very strictly territorial. So again, if that territory that you're doing business with maybe has more permissive IP laws, is that going to be problematic? So just thinking about geography a little bit, and how, and knowing that the people that you talk with from a sales perspective may be different than the people that you are going to be working with from an R&D perspective. And so just because the people you talk with are in Europe, for example, but then the people that you're actually working with may be in Singapore. And so do those different time zones and jurisdictions, across all the different parts of the company, are those conducive to the work that you want to do with that company? Thinking about security and conflict of interest management, obviously, especially with app development, medical device and things like that might be a little bit, I guess catheters could get kind of sticky, but more unique medical devices and things like that, I feel like conflict of interest is easier to manage. But when you start getting into app development and maybe even like catheters and things like that, I could see, there are companies that specialize in doing certain kinds of things. So they're probably going to have multiple clients at the same time where they're developing similar technologies for these different clients. So how do you manage and, how do you vet that third party to make sure that they're managing potential conflict of interest, right? Do they have separate floors and separate personnel and entry and data management systems for all these different clients that might be a conflict, so that one person who's working on your project can't see the other stuff for another client? Just how do they manage that, right? Because you don't want somebody working on your catheter who's also working on Bard's catheter, right? Making sure that they have relevant experience and expertise. If you need an FDA compliant device, do they have FDA experience? If you are working on medical devices, do they understand the requirements that, medical devices have? If it's some kind of wearable, there's obviously, battery life and charging and different attributes of wearables that are more known in the art. Are they familiar with that? If it's an app development, is it, if you want React Native, do they know how to develop React Native apps? If you want native to particular platforms, do they know how to do that? And so just really making sure that they have the relevant experience. Make sure that what kind of working model that they have. Is it time-based, fixed rates? Is it feature-based? And making sure that works with you and your budget, of course. And then I think the other aspect is cascading contractors. Is all the expertise in-house? And are you going to be able to touch base with any of those contractors or people you're working with? Or are they using additional contractors on their back end to accomplish work? And how much do you care about oversight into those other people? Do you care that they're using maybe additional contractors to execute, or do you want to have more insight? What I think you have to be careful with in general is that if you have so many different groups, or if there's different groups within one company working on the product, how do you make sure that they're all coming together in a harmonious way to deliver the product that you ultimately want? We had a client that was using different contractors to build different parts of their device. And when it finally all came together, they started having different technical problems that they just didn't foresee until it was all kind of put together, because nobody was talking together. They were all kind of siloed. And so then they had this, product where it was like, okay, this is a great, maybe, MVP, but we have a lot of things to fix for it to be an actual viable product, because all these things were kind of developed in a vacuum and kind of put together at the last point. So just how do you manage that workflow to make sure that doesn't happen?
Yeah, it's so important. I think this phase, one of a slightly different example about where this becomes so important, and I've seen so many times, is for more in like a manufacturing space, for a brick and mortar, manufacturing company. Almost, or at least it's very common for people to outsource the equipment manufacturing to, these big equipment manufacturers. And when people have unique processes, materials, unique products, Often the manufacturing equipment has to be tailored to make that product, of course. And then the company who has this unique IP needs to teach all of that in great detail to this equipment manufacturer so that the equipment manufacturer can make the right tool to actually produce this novel thing,
Right.
And that is such a difficult relationship because the equipment manufacturers have huge motivation to take everything that you've just taught them about how to make these things great and tell all of their other clients. It's just like that's just the motivation is there. So picking a good partner, and shoring up your own IP, making things really clear, working out the agreements all up ahead of time, it's just so important to, like, in the dating phase, to get all that stuff thought about, out on the table, discussed, cleared up before you actually engage and get into the work phase.
Yeah, you really want to make sure it's going to be conducive and you can have full oversight, right?
Yeah, and just, is it a good partner? Or do you trust them? And do they, is it going to be something that that will work out? The pros outweigh the cons, if you will, because it's very difficult to you can't do everything in-house. You have to engage in outside firms. Oftentimes it's much more efficient, and so there's risks, but there's ways to mitigate those risks, right? By finding the right partner, having the right agreements, and then doing all of what we've been talking about, filing your provisionals, making sure it's really clear what you own, and all that.
Yeah, absolutely. Okay, so you've dated and vetted hopefully the right partner, or at least narrowed it down. So kind of moving into the engagement or prenuptial period. So again, the whole goal of this is that you're going to come together, you have your NDA, maybe some patent pending. They have all their tools. You're going to come together, create beautiful IP, beautiful products. At the end, you're going to separate, right? You're going to have more IP ideally, and they're going to be left still with their core things that they brought to the table. And so in thinking of prenuptial contracts, before you kind of engage with engineering firms, really think about a contract is, hate to think about it this way, but it has to be almost like the worst case scenario for how a relationship could end up, and building provisions around that worst case scenario. Because honestly, contracts only matter when things blow up. They don't really matter if everything goes smoothly, right? So you kind of want to think about your scope of work and make sure it's super clear, non-disclosure agreement language, intellectual property ownership language, termination clauses, and other legal clauses. So thinking of scope of work, you want to think of expectations, deliverables, timeframes, and guarantees. And this is super important. The image I have up on this screen is one person thinking of a square, one person thinking of a circle, and one person thinking of a triangle, and they're all thinking they're in agreement. And how many conversations have we had with clients or other people where everybody thinks they're all on the same page, and then something is created, or there's a claim that's created, and they're like, oh, well, that's not what I thought that was going to be. And so it's just so critical to really map out what the work is going to look like. So again, expectations, for example, for software, can they use open source software? Or if it's devices, can they use off the shelf components? Is it an MVP? Is it actually like an FDA ready product? What are they creating? You want to outline all the deliverables. Do you want FDA, paperwork for the FDA to kind of start putting it through that process? Are they going to be using some kind of framework, agile framework that you're familiar with, or what they kind of are used to in-house? You also want to consider what kind of time frames there are, what kind of contracts you have in terms of feature-based or time-based ones. And so if it's feature-based, that's great, because you can then agree to all these different features, and you lean on them for their expertise for how much time these features, might take, or the cost for them. Versus time-based, sometimes it's a little dangerous, just because, as we know, you always end up with encountering problems in development, and you don't want them taking shortcuts to meet a deadline, a time-based deadline, when ultimately you just want that feature. And so just really thinking about what really matters, and also making sure it's an appropriate scope of work, right, for the engagement. What is your MVP? Like, so what's your FDA product, whatever the case may be. Guarantees for software, I think this is more common where you could have code guarantees that it should behave well for X period of time without any bugs. And then maybe you have some kind of maintenance contract with them that says after this time frame, if bugs are found, they'll fix them at whatever rate for you. For devices, I don't believe there's really any guarantees outside of, just the guarantee that it's going to work, right? That we've created this catheter for you and we said that we were going to create it so it would work. And so we're going to get you something that works. But I don't think there's going to be any kind of guarantee of, customer success, market success, or anything like that. So I think guarantees are going to be light, but there does need to be clear lines around expectations, deliverables, and timeframes.
Yeah,
Ashley,
oh, go ahead, Kristen, go ahead.
Oh, that's okay. No, mine was a little bit tangential, so go ahead.
Oh, on the guarantee thing, yeah, like in a product or a tool, you oftentimes are going to have specifications. It needs to ramp up to temperature in X amount of time, or the device needs to, this needs to fit in there, or have this strength, or this whatever. So there's oftentimes, you would have specification, maybe guarantee is a strong word, but you'd have specifications that they are designing around, you know what I mean? And that can be important, I think, in certain cases.
Right.
Maybe
I think it's where the
but
feedback loop comes to, though. If they can't, from like expectations or guarantees, whatever, if you've set some sort of deliverable or some kind of specification that is impossible to reach given other device constraints, then again, like a good open door feedback loop with between the company and the third party to make sure that those things are communicated so that then specifications can be revised, right? Because I know that kind of stuff happens, right? They start developing and there's like, there's no way I can make this drone fly in the way that you thought it would, given the propeller arrangement that we all agreed to. So how are we now going to make it behave like you want to, but then change the design that's still, within whatever other parameters that we have?
Right. Yeah.
And now I know we're talking about the scope of work in like design documents and expectations of delivery and what you're going to get, but something subtle in software is that you've got these people, the one thought of the square, the one thought of the circle, and the one thought of the triangle. Let's look at those as three pieces that are being implemented in a product as software. Whoever is implementing that, and I mean coding that up, generating the actual software code, making that actually function, those people are not considered the inventors. Those people should not be listed on the inventorship if you're filing your provisional, if you're filing any of that along the way. Those are just implementations of the original scope of the design document and the original algorithm, if you will. So something subtle when you're working with engineering firms in that way, remember, just because they created your code doesn't mean they created the idea or had any piece of an original idea. There are situations where it's different than that and they should be involved, but it comes into, did they solve a piece of the problem that you actually are trying to claim, right? That is a little bit different than just implementing your code, your algorithm in code, right?
No, absolutely. And that's 100% because there's, it's like the difference between handing an engineering firm a completely spec'd out CAD file of building a part, right? And saying, here, create this part for me and then send it back, versus basically saying, here, kind of pie in the sky, I want a device that has A, B, and C attributes that then functions in such a way as D. In that second scenario, there's likely going to be some inventing going on. In the first scenario, there's no inventing by the third party firm. And same with software. If it's like, you're basically, very clearly, this is all the things it needs to do. And now you're just going to code it up versus, a little bit more open-ended, I just want it to, basically behave like this, but figure out how it's going to do it. Then they might be inventors in that regard.
Right.
So
yeah,
go ahead.
Yeah, I guess the corollary I make there is maybe a mechanical engineer who is working at the engineering firm saying, well, in order to do this requirement from your document, I need 3 notches in the widget, right? And that would be the software guy at the software engineering firm saying, well, in order to make this function and work like you slated it to work, we have to use artificial intelligence and we have to use some machine learning, right? Those sorts of things, those were not initially thought of. Those were not initially proposed or generated by the actual IP originator, right?
Right.
So then those people should be part of the inventive entity. And I say those people, I mean the engineering firms in those examples.
Yes, that was a perfect TM because so ownership. So actually first inventorship is the person who has contributed to the conception of the invention to the point that their idea is clear enough to be able to be reduced to practice, right? It doesn't have to be reduced, at least actually reduced to practice. It could be just constructively just written in reduction to practice. Whereas ownership is the entity that has the authority to file the patent applications and enjoys all the rights and benefits if the patent is assigned to the entity. So from just inventors, if you're the inventor and there's no entity that it's assigned to, you're also the owner, right? Inventor equals owner. But if you are an employee who has signed assignments to the company or has assignment provisions in your contract and work for hire provisions, then those rights are going to flow to the company that you work for. And similarly, I think we'll get to this later, but if you have an engineering contract, a contract with the engineering firm, there should be IP provisions in there that basically say that your company owns the IP and not the engineering firm, unless you have created some kind of unique arrangement, right, where the engineering firm gets some kind of equity or something like that. Because they have part ownership or something like that, but otherwise your company should own it. So this, continuing on the IP ownership piece, remembering that the creator is the owner unless a contract says otherwise. So if the engineering firm creates it, like fully, conceives of it, then they're going to be the IP owner unless it's in your contract that your company owns it. You want to include a work for hire provisions, especially for software that, again, just because their people code it, it still means that you would own any copyright or IP resulting from that work. And then if you need to require the firm and its employees to participate in IP requirements. So that means making sure that you're getting contact information for anybody who participated in ideation and whatnot, because you will need paperwork from them for a long time, over time, for any IP that was created. So then, other termination clauses and other legalities. Of course, you're going to have, some kind of course of action in there. What causes termination, or what's the course of action for termination? Where's the jurisdiction for any resolution of any issues? A lot of times it's in the state of the company, the contracting company, not the third party. But again, that's usually up for debate sometimes. Is it through arbitration or litigation? You might want to have some right to audit clause as well for some of these in terms of what triggers some kind of termination. And maybe you have regular audits to make sure that they are complying with the contract. And of course, if they fail to audit, then that's, a right to terminate the relationship. Some kind of indemnity clause, who pays for litigation or arbitration, and any kind of joinder agreement, who can they join in? If they're using cascading contractors, are those contractors part of the dispute? Should there be a dispute? So just thinking through all those different things. Again, a contract is for when things don't work out appropriately, right? Not for when they go right. So then actual product development is when things actually get the marriage, when things actually get developed. I think the biggest thing is, don't let yourself go, because this is actually the point where you need to be the most engaged and understand what's happening, what they're developing, and have an active type feedback loop. You want to understand the sources of innovation, again, who's owning the code, making sure that you have access to different repositories, making sure that you understand the impact of agile development, and how that impacts your IP. You want to keep on assessing patentability and freedom to operate. That is your responsibility, as we'll discuss. Consider open source considerations, and then various device considerations. And then, just as a joke, you want to wear pants occasionally. Just because it's marriage doesn't mean, like I said, you gotta let yourself go. So So anyway, sources of innovation. So obviously the vendor has their own code, right? They might have code bases that they're working from, or libraries. They might have test fixtures that they're using. They may have some base devices for different things. So they're going to have their own IP, right? That's their own base stuff that they bring to the relationship. There also is outside sources of that contribute to the innovation, right? There's open source software. There might be off-the-shelf components. If it's an MVP, they might be using and harvesting pieces of devices from other things to kind of make something work and as a proof of concept. But of course, as you move more towards an actual commercially viable product, you move away from off-the-shelf components to more custom, things as needed, right? You're not going to reinvent battery technology or PCB technology to develop a product, but you might want to move away from some of those technologies as you get more to a commercial ready one. There also might be compliance constraints that cause innovation to occur. Obviously, the FDA is going to put constraints on different innovation, or maybe it's the App Store. There's different constraints that they put on from a software development perspective. So just thinking through that and if that's going to lead into innovation as well. And then lastly, obviously, as part of all of this, there's going to be new code and new devices that are created. And that's, of course, where innovation is going to come into play, but some of these other things may feed into it. So again, code ownership, you don't want to wait for project completion. Get admin access to the code repositories. If you don't have access to those repositories, you don't own the code. So, go ahead.
Just a quick comment on that last thing is just the difference in, this is getting in the weeds a little bit, but I think it's kind of relevant to that, is like when you're thinking about patenting some invention, you've got the inventorship, which really goes on the claims and what is novel, not only just the claims, but what actually is novel and inventive in the claims. So you might have something off the shelf or something that's known or something even not very well known, but outside of your invention that's described in the spec that may have been contributed from this third party, but they still may not be an inventor on invention if your key inventive concept that you're claiming does not include that piece. Right. So yeah, just a
it's true.
Comment on that. Yeah.
I think it brings up a good point too, is, especially when code's involved, understanding what their code base is contributing, because you don't want the inventive piece lying in their code base. There's no way they're going to let you own that. Right. I mean, I don't know how that would come out to be, but I mean, but if their code base somehow lies as part of the inventive concept or something, that's going to be huge problems. And so and I honestly don't know how you would tease that apart. I think it's just going to be, again, really tight feedback loop and understanding what all the things do.
There's two ways to do that. You force the coders to comment in a certain fashion and to uphold a standard of implementing their comments across their code. It's a pain. It's not something everybody has really good a good grip on or a want to do it. Really good coders do. Really good coders who get stuff implemented but get it done fast don't often continually comment their code. So if you put that as part of a contract that, I'm requiring that you've either got to extremely comment this or get my selected third-party review to do code reviews at X amount of dates. And so then you would have a third party who would attend these code reviews, and they would look over best practices of what's going on in the code. They would know what's going on in the code. And that would be a kind of an outside expert that you, as the owner of the IP or of the company, asking the engineering firm to do some work. That would be your way to oversee some of that without having to dig into the technical nitty-gritty code. If you're okay looking through code, you still want really reasonable commenting, and you want them to do it for yourself, but also for transportability. If that engineering firm goes away, or you find a new, better engineering firm you'd like to work with, to change that code. And it's so much better if somebody's actively commented the code in a useful way. You can do it the other way, but it takes twice as long to sift through all of the code and figure out exactly.
I remember Josh talking about that, is like code commenting or whatever, or annotation, so you know what things do what. And yeah, that's a great point. Just it's like even the portability, like you said, being able to use somebody else later or make changes later. You don't have to figure out what step does what when, there's clear distinction.
Yeah, I mean, it's hard enough to pick up a new product with new code. Having done sustaining engineering in my career before, it's hard enough to just fall into that role and pick it up. But if somebody has done something logically in the code and commented why they've done it, it's so much easier than spending 2 days trying to figure out why they did this way.
Right. That's such an asinine way to do that. Oh, there wasn't.
Right. And for most the first day, you're like, what the hell, right? Like, right. guess I'll get another cup of coffee because I can't figure this out. It's something you can put in your contracts to say, if you're going to do code for me, I need it to be up to snuff, right? It needs to work, but I also need to know, reasonably what's going on. And that doesn't mean every line, but every function or every 5-page chunk of code that does something specific. I want to know why, or I want it marked.
Yeah, I feel like you really need to do your homework even before, like if you're a person or a company that has no software experience at all, almost consulting with somebody before you even vet partners around what questions to ask, right? Because I feel like if you're new to the product development or like FDA, what questions would you even ask a potential partner if you've never been down that road before? Recommendations can be good, right? If somebody's had time-tested relationships with engineering firms that they know are good for FDA or code or whatever, that's one thing. But I know, like, just thinking through it now, if I were to do this, I don't know if I would know the right questions to ask some of these groups. So you'd almost want some kind of consultant up front to say, here's all the things that you should ask before, if you're looking for different kinds of firms.
Yeah. And there are a lot of good coders who work on contract because that's how they want to work. If you can find a good one of those who will do, this kind of review for you every once in a while, even, once every 3 years, if you can get somebody to do 40 hours of code review and analysis to help you in the future, it's worth the money.
Yeah. Dividends long term.
Yeah. I mean, the only time that doesn't make sense is if it's like graphical user interfaces. You're just generating objects on the screen. That's not as important. You're going to own the end GUIs. You're going to own, if you try to claim or design the end GUIs, and you, of course, include the appropriate inventors if you happen to have somebody on the engineering site as an inventor. But that's not as important to get your comments and whatever correctly. But if we're talking about firmware, device firmware that runs the guts of your device, it's hugely important that you do that. That you make sure that the comments are there, that your algorithms are laid out appropriately so that you could say, okay, this is the algorithm that I patented in this patent application. And it's even more important if you go to sell that end product as a whole. And I don't mean like retail, I mean like get rid of the IP, get rid of the company, and you're selling everything. People are going to want that. They're going to want that mapped. To say, do you really own it, and who implemented it, and where do I go if I need to update it, right?
Yeah, pretty bulletproof. So, and then thinking about agile methodology, traditionally from a waterfall practice, feature sets and products were basically fully spec'd out and then kind of thrown over to developers who then built it. Now it's a much tighter timeline, right, of developing X features and then pushing them out and then iterating on them or adding new features and pushing them out. And so you just want to make sure that you're accounting for what they're pushing out, making sure you're getting protection on that before they push it out if you need to. And so capture inventions as quickly as possible, matching that fast pace of agile. And this goes for devices and for software, right? Where devices are changing rapidly over time. Maybe the specs that they give you originally for an IP disclosure aren't the specs that end up being the commercially viable ones. And so, just before they go to design freeze, making sure that you're getting those. And so with that as well is managing patentability and freedom to operate of newly developed products. There is no guarantees in this world. And most engineering firms do not participate, at least they're not going to be the ones instituting patentability searches and freedom to operate searches, right? They may look through some patent art, they may look through some of the field and kind of understand what's out there, but they are not going to be responsible for patentability and freedom to operate. That is fully you and your IP counsel's responsibility. And so just making sure that you're doing searching and sharing those results with the engineering firm and talking through what they're developing relative to the art and making sure that you're designing around where necessary or having really good arguments for when something has to be a certain way. And so just making sure there's that bond between your IP counsel, you and your engineering firm to walk through things. We've had a couple of clients that have worked with engineering firms over time, and we've had meetings with them where we do searches, we walk through the art, then we can talk, around how things are different, where the development is going relative to what we're finding and stuff like that. So it can be highly valuable. So, and again, just from a understanding patentability and freedom to operate, patentability is your technology is new and inventive, and that's over all of the material that's currently out there, including publications, websites, patents, journal articles, similar things. Freedom to operate is that there is not an issued patent that prevents you from making, using, selling, or importing your invention into the US. So just because you get a patent on your technology doesn't mean you can actually practice your technology. So you basically have to have patentability to have a patent, and you need to have freedom to operate to actually make and use and sell your invention. So you need kind of searches on both those fronts. So quickly, open source considerations, just making sure that it's very clear and understood what kind of licenses are okay. You obviously don't want any licenses that require your code to be shared openly, right? So more like those copyleft kind of software licenses. You want to make sure that the engineering firm is not using those. You want to just, again, making sure you understand what code is being used when and how, and that they understand what you're okay with and what you're not okay with. So you want to take an active role. You want to, again, establish clear expectations. And you also, this kind of goes towards Kristen's commenting and things in the code base. Make sure they clearly list all the software packages that they use, all the open source software packages they use, and maybe even where they did in the code base, so that you can be sure that they used ones that were good open source software and not more viral open source software.
Yeah, and remember, you can still get that claim if you're just receiving something from an open sourced output, right? You can still use that open source receipt of information, but you have to do something inventive with it in your claims.
Absolutely. And then, thinking of FDA compliance, there are rules with the FDA. There was a I've never even watched this movie, but it's like,
get a bottle of wine, sit down and watch it. You'll die laughing.
It's Big Lebowski, right?
Yep.
Yeah, so it's the thing is smoky. This is the FDA, and there are rules. Of course, he wasn't talking about the FDA at that time, but so again, considering where innovation might be coming from and how you engage with engineering firms, just making sure that they're going to help you prepare things for FDA administration, for the Food and Drug Administration. So that's any documentation, test data, whatever. Making sure that they're using the right materials, and again, some of these things may impact the innovation, right? Depending on what constraints there are. And then always keep the end goal in mind. If you're prototyping, proof of concept, and user ready, because that will also impact, patentability, and making sure that you're not patenting things that aren't going to be in the final product either, right? Just because they're in your prototype and it's inventive, is it actually going to be in your consumer product? Because those might be different things. And so lastly, obviously divorce is inevitable after you develop the product. So just, walk through that exit plan that you developed ahead of time, making sure you're getting assignments and declarations for the intellectual property before you fully disengage. But again, remembering that there will be this requirement for a long time, for upwards of 15 to 20 years potentially. So as the more you can create a good relationship and keep that good relationship, the better, because you will need them here and there throughout time. Make sure you provide adequate notice per your contract. So if the contract says 30-day notice of termination, be nice and give them 30-day notice. Make sure you transition the ownership of the infrastructure, code, devices to whoever's going to be taking it over, whether it's your company moving things in-house or it's another new third party. You want to cut off access to network systems, assets, and data. Make sure you destroy any vendor data. Of course, pay your bills. And then continue third-party monitoring too. I would keep it, for some kind of time period, maybe a year or so, kind of monitor that third party's activity what's coming out and making sure that they are complying with the terms of that agreement, whether it was some kind of non-disclosure, IP, make sure they're not developing something similar for somebody else right after you disengage. So some kind of level of third-party monitoring probably wouldn't hurt. And lastly, some anecdotal experiences that I've had is that, we've seen where a product was developed without a development agreement in place. And in this case, it was a software product. And then once that new product was created, there was disagreement around who owned the product because there was code base from the third party in the product, but yet the client had paid for the product. And so there was a huge disagreement, lots of phone calls. And then we finally agreed to basically co-ownership of some of the product because of the base code that was used by in that code base. So one of the products was fully owned by the client and one was a co-ownership. It wasn't the worst case scenario because that third party had also invested in the client. So they did pay for it, but they also did give the engineering firm some portion of equity or something. So it wasn't the worst case scenario, but still not ideal because if you think of investors and things like that, when you go to sell the IP or license it, now you have co-ownership and everybody has to agree to that selling of the IP or the company. So it's just not ideal.
And a reminder from the IP perspective, if you have filed something and you have not gotten the inventive entity right, you have not credited your engineering firm, for example, they can challenge your patent and your patent can be invalidated because you didn't put the correct IP, inventorship on file.
And actually we've seen that as well or at least even just had these discussions where because a company is paying for development, they want to say that they are the inventors, right? But that's a false equivalency. Just because you pay for it doesn't make you the inventor. It makes you the owner if your agreement says so, but it doesn't make you the inventor. And so, I always say this, it's better to be over-inclusive than under-inclusive. Nobody throws a fit, or at least generally, nobody throws a fit for being included on a patent, but they sure do throw a fit if they're not included, right? So if you have an engineer, something that finds that they were left off, especially if it's intentionally, that's just a recipe for disaster and invalidation, 100%.
Yep. And you can fix it. You can fix it at any time. Yeah. But if you refuse and they prove that they are part of the inventorship, you're really in trouble.
Shame on you. Get a finger shook at you. So I guess the overall key takeaway is protect as much as possible before disclosure using provisionals, carefully vet potential partners, and maybe even figure out what questions to ask. Get good contracts. These contracts only matter when things fall apart. So you want good contracts. Maintain access to your physical and digital assets at all times. Make sure that it's in your name and not theirs. Match an iterative IP approach with the development workflow. Know what's getting baked into your product, into your code, and then execute a well-thought exit plan. So, of course, never go to bed angry, which is true in engineering firms too. Because again, you need to make them happy for a long time. Because you'll be partners well beyond the termination.
Yep. And if you ever need anything, a favor to fix code, update something, questions, if they're still in good shape and you're still colleagues, that's a really nice thing. And they're more willing to do stuff for free for you, especially if it's one-off questions. So
yeah, exactly.
Good talk. That was really good, Ashley. Thanks.
Super interesting. Thanks, Ashley.
Yeah, no, happy to share. So thanks for participating and have a good rest of your day then.
Yes. Thank you. Absolutely.
Thank you
too. Both you guys. Thanks. Yeah.
Thanks. Bye-bye.
Bye.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.